I'm going to kick off the North Carolina Judicial Candidates Forum for the NCADA. This is a long-standing tradition. My name is Ashley Brathwaite. I am based out of the Raleigh office of Ellison Winters. And as immediate past president, I have the privilege and honor of hosting the judicial candidates. And we're going to start with those who are running for seats on the North Carolina Supreme Court. We'll then move to those candidates for the North Carolina Court of Appeals. So if I could go ahead and call up Justice Allison Riggs and Justice Jefferson Griffin, please. And the format for the forum changes with each election cycle. This year, our agenda is going to start obviously with the North Carolina Supreme Court candidates. Each candidate will have a couple of minutes to introduce themselves, and then we have provided a question that we would like them to address, and I'll go over the question. So if we'll start with you, Justice Riggs.
Just speaking here.
Yes.
Good morning, everyone. For a few more minutes, I'm Justice Allison Riggs. I am the newest member of the North Carolina Supreme Court. I am so honored to be here with you today to learn more about your needs and your perspectives and to allow you a chance to get to know me better. My judicial service is informed by my deep well of experience in litigation, and so I feel much kinship sitting here with you today. For nearly 15 years, I practiced in state and federal courts all across the South. I was blessed to have a practice that encompassed both trial work and appellate work. So I conducted many multi-week complex civil litigation trials in state and federal courts all across the South. But then I also shepherded those cases through appeals and was honored to argue in state Supreme Courts across the South, the Fourth and Fifth Circuits, and twice in the United States Supreme Court. And the reason that's relevant is because I come to you with a deep level of respect for the work that you do, having recently been in your shoes, and you can expect from me as a jurist that I will be respectful of how hard you're advocating for your clients. I'm also very proud to come with experience both on the Court of Appeals and the Supreme Court building bridges. I am committed to working with my colleagues, learning what they need and what their view is so that we can find common ground and get to the right answer. So I'm proud that the 50 opinions I wrote at the Court of Appeals almost all garnered the votes of my colleagues across the aisle. I was proud to recently hold the majority in a Supreme Court case in the face of dissent because I would sit down and talk with people. It is my intention to listen and be thoughtful, and just as I seek to persuade, to be persuadable and persuaded by good logic and great law. So very eager to be with you this afternoon to talk more, and thank you for having me.
Thank you. Justice Griffin.
Hey, good morning. I'm Judge Jefferson Griffin. I have the honor of serving you currently at the North Carolina Court of Appeals. Been there since 2021, the first of the year there. First off, thank you to this organization for your support in my last two statewide elections. The last one, I had to have some surrogates speak for me, my wife, Katie, and my good friend, Kirk Warner. I was a federal employee and I was on federal orders and deployed to Iraq, and I could not participate in a campaign activity. So it's good to be back with you in person. In the brief time we have for introductions, I just wanted to highlight, you've got our resumes, you know about our experiences. 2 points that I just wanted to make that I think are very pertinent to your organization. One, I've actually done the job you've done. My first job in the legal profession was with Wallace, Morris, Barwick, and Stroud. Stuart Stroud, I got to visit with him, but I actually did civil defense work coming out of school. Had a great perspective there, got to try cases very quickly. I've also practiced a lot in our North Carolina Superior Courts. I was a prosecutor in Wake County for 5 years, tried dozens of jury trials, in that courthouse. So lots of experience in the courtrooms that you practice in. Served as a district court judge, criminal and civil matters, for 5 years in Wake County, also another very busy courthouse. And then I've been on the Court of Appeal since 2021, where I've authored over 200 opinions that's the best evidence of what we're going to do on the bench. And I hope that you'll take the time to review those if you hadn't already. But appreciate what you do so much for our state. It's so important that we have seasoned and quality litigators across the state to make sure that everybody gets justice in the courtroom. And this organization does an awesome job with that. And I am thankful. Look forward to speaking with you some more.
Thanks very much, Judge Brick. So the question for the Supreme Court candidates this year is that North Carolina's economy has diversified over the past number of years and has become increasingly international in scope. To what extent do you believe that the law of other jurisdictions should be used by the appellate courts in interpretation of the statutes or in the adjudication of disputes over the common law in situations where there may not be a clear answer based on just North Carolina law alone? And Justice Riggs, if you would be the first to address that.
Do you need me to use the microphone?
It's completely up to you.
All right. We'll use the microphone, so just make sure everyone, okay, I see some nodding. I appreciate that. I really appreciate the thoughtful question. We have a rapidly globalized economy, and it's creating new issues for all of us. One thing I want to acknowledge is that I respect the ability of parties to contract with each other to address the applicable law and the choice of law. And so I think starting from the mutual assent and understandings of the party is something that's very, very significant to me. Beyond that, the legislature has told us in determination of foreign law what it expects the parties to do in terms of preservation at the trial court level, that the determination of foreign law is something that trial courts can look to outside sources to help inform them, and that it's a question of law that appellate courts treat as such. And so I'm very deferential to the legislature on that front. Beyond that, though, these questions are still going to keep landing on our table, landing before us. And I think the way our court has dealt with foreign in the domestic sense, but other states' jurisdictions is very informative. Obviously, we're not bound by it, but we only have to look back very recently to a unanimous North Carolina Supreme Court, where the Supreme Court talked about the way in which Delaware law has so well developed and so informative in areas of North Carolina law that have not yet been developed. And that decision that I'm bound by instructs us that it is good and it is helpful to be informed by that. But at core, I take very seriously the challenge interpreting foreign law, whether it's another state or another country. There are obviously some potential pitfalls that need to be navigated carefully. I am not scared of those. I think the statutory and rules onus is on us to do the work and to figure it out. But what I don't think we should do is be fearful to do the work, to learn the law, to apply the law for the correct answer, because it is new and different. And to the extent there are any public policy concerns that arise out of a different jurisdiction, again, I'm bound by our state Supreme Court's instruction that just because law is different doesn't mean that it violates the public policy of our state. So I think these difficult questions, which we're going to see more and more of, are ones that I hope I will convince you that I will deal with thoughtfully, be a critical thinker, be unafraid to do the research and the work to get to the right answer.
Thank you.
Thank you for the question. I think when you addressing that, it's something you need to be very careful about. Looking at an outside jurisdiction for any kind of authority is pretty is like a slippery slope to me. We're bound by what our legislature and our Constitution say, and I think if we look at anything other than the original meaning and sometimes the original intent of what that is, we're going down a path that can certainly lead to us moving the law from the bench in a direction that we're really, that's not our lane. And so I'm very cautious about using outside jurisdictional stuff. But to say that we never look at it, it would be probably an error too. I think from an academic perspective, it can certainly be beneficial to look at what other jurisdictions have done. But I think when you look at that question too, you look at, what do we do as jurists? What is our judicial philosophy? How do we address these? And so my kind of North Star or bedrock is going to be what was the original meaning of the statute, Constitution, whatever our North Carolina law is that we're having to interpret. And on top of that, when we're addressing that issue, my preference generally is to hold it as closely as we can. And if it is something that's truly ambiguous, we make the decision that we have to make to move that question. And then at that point, always the General Assembly can come back and address it. And certainly different from the Court of Appeals, which is error correcting court, the question before the Supreme Court would be the final word, and they have a little more authority to go down that road. However, still with the idea of making that holding as tight as possible for the court to address further in the future if there's a different set of facts that are a little bit off, but certainly for the General Assembly or the people of North Carolina through amendment processes to correct. So while I think it's instructive academically, I would caution all of us to be careful when using authorities outside our jurisdiction.
Thank you both. Thank you both for your introductions, for your comments, for being willing to entertain a question that bears on all of the civil defense bar, and that we spend so much of our time in Superior Court, in business court, and obviously in the appellate courts dealing with new issues on behalf of our business clients. We appreciate your time for being here today. Thank you. And at this point, if we could have our Court of Appeals candidates please come forward. We'll pull the candidates for seat 12, 14, and 15 all at the same time, just to give us some continuity here. You can sit wherever you please.
Okay, would you like the candidates for the same seat to be together? Or?
Well, actually, Mr. Eldred couldn't make it here,
Okay.
so you can sit wherever you'd like. You can come join Mr. Murray if you want.
Mr. Murray's such a great speaker, I don't know if I'll maybe I can get some inspiration.
Okay.
Learn to be a,
Good morning.
learn to be a politician.
Thank you. So with us today, we have the candidates for the North Carolina Court of Appeals, Associate Judge, Seat 12. We have Mr. Thomas Murray and the Honorable Carolyn Thompson. For Associate Judge, Seat 14, we have the Honorable Valerie Zachary. Mr. Ed Eldred had every plan and intention of being here and then got called into court. So he is submitting a video introduction and response to a question that we had posed to him. So we will have that posted through our seminar materials. And then we also have the candidates for Associate Judge, Seat 15. That's the Honorable Christopher Freeman and Mr. Martin Moore. Perfect. We gave folks the liberty to sit where they please. So let's start to my left here. Well, we'll go in the seat order. For seat 12, let's go start with Mr. Thomas Murray. If you would, give us an introduction, please.
Good morning, ladies and gentlemen. My name is Tom Murray, and I'm a state prosecutor just north of Wake County. I'm an assistant district attorney. I've been an attorney for over 17 years, graduated from Campbell Law School when it was in Bowie's Creek. But professionally, I'm a pharmacist and an attorney, which means I can fill your prescription or write your will, right? So I just hope I don't have to do that on the same day. But I've served in elected office for about 10 years. I got elected when I was in law school at Campbell to my town council. Got recruited to run for the state legislature, served a couple terms where I was happy to partner with the Association of Defense Attorneys on various policy reforms. After leaving elected office, I served as chief legal counsel and chief of staff to Chief Justice Mark Martin, helped him run the judicial branch for 4 years. I joined the National Guard as a 37-year-old father of 3. So while I was working for Chief Justice Martin, I deployed to the Middle East. I got to experience what countries without the rule of law and what without law and order are like. But most importantly, I'm a husband and a father of 3. My wife and I have been married over 21 years. In true bipartisan North Carolina fashion, have 1 daughter at Chapel Hill and 1 daughter at NC State. But I also have my 10-year-old son here with me who is getting a crash course on civics and North Carolina geography, traveling the state with me. But let me tell you, the reason why I'm running for the Court of Appeals is because I believe that law and order is what separates America from every other country in the world. And having seen countries where they haven't slept under the blanket of freedom that you get to enjoy every night, the importance that our courts play in protecting public safety cannot be understated, with the Court of Appeals being an error-correcting court, and 50% of the cases that come to the Court of Appeals involving criminal appeals. I believe my background as a state prosecutor and as an Army veteran will be well deployed on the Court of Appeals. My name is Tom Murray. It's a pleasure to be with you today.
And Judge Thompson.
Good morning. My name is Carolyn Thompson, and I'm currently serving you on the Court of Appeals. I'm appointed in September of 2023 by Governor Cooper to fill the seat of Justice Allison Riggs. 27 years ago, I sat where you are as a trial attorney, opening up my own private practice in family law in what is now the 11th Judicial District, used to be the 9th Judicial District. As a trial attorney in the areas of family law, I also served as the county DSS attorney, prosecuting cases of A&D court and non-supportive children. And then in 2009, I took the bench as a district court judge in the same district. Stayed there until 2018 when the governor again tapped me to be appointed as the resident Superior Court judge, replacing our Judge Robert. I replaced Judge Robert. Just lost my thought. Just what brain fog. And serving on the Superior Court bench, as you can see, I'm on a campaign trail with 100 counties, and I'm lacking coffee. But in 2018, I stayed on the Superior Court bench to complete the term, and while serving there, I was also tapped to be a certified mediator in the area of civil litigation. After I left the Superior Court bench, went back to trial practice, and stayed there also representing the County of Warren as a county attorney and advocating for domestic violence victims. Somewhere in there wrote a book about domestic violence and authored a book about domestic violence. But I didn't just sit on the bench. I also returned to the community to serve as a youth mentor, volunteer teen court judge, volunteer judge of a truancy court, keeping kids out of the juvenile court system. And then in 2023, I started serving as a deputy commissioner with the Industrial Commission, hearing cases involving workers' comp and also tort claims with inmates in the prison system. And then here comes September 2023, and the governor again taps me to be appointed to the Court of Appeals, where as of to date, I have authored about 50 opinions. 11 of them have been published, and I understand from the course material, you all will be talking about me on tomorrow about some of those opinions. The best part about my existence is that I'm a wife. I'm a mom to a blended family of 5 adult children. We have 6 grandkids, 3 pets. One of them is in the hotel right now, probably still chewing up my favorite sandal. And just welcoming this opportunity to be before you again.
Thank you, Judge Thompson.
Hobgood.
And the candidates for Associate Judge seat 14 with us today, we have the Honorable Valerie Zachary.
I'm not the speaker that these people are, and I have my notes. My colleagues on the court always make fun of me because I have notes all the time. For everything. Everything we do, I've got notes on it. I'm Judge Valerie Zachary from the North Carolina Court of Appeals. For almost 10 years, it's been my pleasure and my honor to serve the court and the state, and I'm running for re-election now. I'm from Yadkin County, which is about a half hour west of Winston-Salem on the way to Boone. I grew up there and then went to half a junior high and high school in Ann Arbor, Michigan. Got a scholarship to Michigan State University, where I graduated with honors in multidisciplinary, French, economics, and political science. I then went to Harvard Law School, graduated cum laude. While I was there, I was invited by Professor Lawrence Tribe to serve as his research assistant in the revision and editing of his treatise on American constitutional law. I was invited to critique Ames moot court briefs, and I was also a member of the Harvard Legal Aid Bureau and the Women's Law Association. When I graduated from law school, I joined the litigation team at Kennedy, Covington, Lobdell, and Hickman in Charlotte, which is now K&L Gates, and I loved it there. Absolutely loved it at Kennedy, Covington. But then I married my husband and ended up right back in Yadkin County again. We practiced law together for 26 years. And I say we, I should include my daughter Rachel. She basically grew up in the office and grew up listening to us. When she was like 4 years old, she got really angry with me one day, and she was pointing at me and she said, "You're unconstitutional." Like, and I think she thinks thought unconstitutional was a cuss word or something. She knew it was bad. She knew that was bad. And she's not a lawyer now. She just advises everybody on law. In 2015, I was appointed to the court. In 2016, I ran statewide and won my election. I've authored approximately 600 opinions and participated in another couple thousand. They're all available for your review at nccourts.org. In all of those opinions, I have held fast to the principle that the Court of Appeals is an error-correcting court. It's not our role to make law or make policy. I'm fair. I work hard. I'm the oldest of 5 children. My mom says, I immediately started screaming fairness, at a very young age. And I'm experienced. I would appreciate your support. Thank you.
Thank you. And next, the candidates for seat 15. We'll start with the Honorable Christopher Freeman.
Good morning, everyone. I am Judge Chris Freeman. It's an honor to be here with you today. I appreciate this organization and the hard work each and one of you do every day. As a judge in the courtroom, I see it firsthand. And I see some of you looking around up here like, I know that guy. And some of you may. Have you ever seen Talladega Nights? I was an extra in that movie. So I was born in North Carolina and grew up in Denton, North Carolina, Randolph County. Graduated from Asheboro High School, home of the Blue Comets. Attended High Point University. Before it was a resort. It's much nicer now. And I went to Regent University. The motto is Christian leadership to change the world. Now, I began my career in private practice some time ago and then very quickly began working with the DA's office as an assistant DA. I served in that capacity for 8 years with the Honorable Justice Berger, who was the elected DA at the time. Then in 2014, I ran for district court judge against the incumbent, and I won. I've been unopposed the next 2 terms. So I've served for 9+ years as a district court judge. Now, we do a lot of things in district court, civil and criminal, see the whole spectrum. And I've always served with dignity and honor and respected all who come before me, on and off the bench, follow the law, uphold the Constitution, and I do not legislate from the bench. Also very involved in my community. I go to Osborne Baptist Church. I'm on the board of the United Way, Betsy Jeff Penn 4-H Center, the National Wild Turkey Federation, Monroe Fire Department. And so now we'll circle back around to Talladega Nights. And if you've seen that movie, you know the quote from it is, if you're not first, you're last. Now, I think what you'd expect for a appellate level judge is experience. I've told you I have it. You'd want the character and somebody can understand and follow the law, treat everybody fairly. And that's who I am. Now, with your support and your vote in November, I will be first. And I look forward to serving you on the North Carolina Court of Appeals. Thank you.
Thank you. And next, we'll hear from Mr. Martin Moore.
Thank you. Good morning, everyone. I guess afternoon now. My name is Martin Moore. I am honored to be here with you all to share a little bit about my run for the North Carolina Court of Appeals, seat 15. To give you a little bit of background, it's kind of great being in a room full of attorneys because I don't have to answer that first question I usually get during my stump speech, which is, what the heck does the Court of Appeals do? Y'all know that, hopefully. But I do want to share a little bit about my background and who I am so you can know the experience that I'm going to bring to the bench. I began my education at UNC School of Law. Really kind of doubled down on knowing I wanted to be in the law. I didn't know exactly where, and I was grateful to have an opportunity to see firsthand. One of my first experiences was working at the North Carolina Supreme Court and seeing firsthand the amount of work and tremendous dedication it takes to get the decisions right. Every single day we went in, start way earlier than the time I was comfortable getting up, and review those cases, dig through that, review the law, make sure you know where everything sits before you end up digging into this and writing your own opinion. And having that work ethic and drive to understand exactly where the law sits was a critical one for me, especially as a young law student. I finished at UNC, went on to start my career here in Asheville as a defense attorney. I did a lot of criminal defense work, helping people through some tough moments in their life, and really came to appreciate in hindsight the amount of value there is in trial experience. There's no substitute for being able to be in that courtroom and having been in front of a jury and know what it takes, not just to argue before that jury, but to make sure you're checking every box, to make sure you're preserving every issue on appeal, and making sure that people understand, regardless of what happens with juries, we know they're unpredictable, that you put your best foot forward on that case and also saved yourself enough issues so that when you go to the Court of Appeals and you know that you're right on the law and you're arguing that motion that got denied, that Judge Thornburg never ruled against me on, of course, that we approach this with the integrity and the dignity that we need to make sure that we're showing up in the best possible way in our clients, not just for the short term in that trial, but making sure we preserve those issues on appeal, because the Court of Appeals is the first and last resort at that after you finish that trial, and a lot of times that's the last stop for everybody. That's where this case and the justice ends for those people. So just outcomes were critical in that sense. After I spent my time getting that experience and that jury trial experience that's so coveted, especially in our defense attorney circles, I had the pleasure of working with one of our local firms, Van Winkle, Buckwall, Starnes, and Davis, where I got to join the litigation and appellate practice groups, doing a lot of work in land use and complex litigation, and some appellate work throughout the country. And one of the things that really stuck with me as I was doing that work was how much time and effort goes into creating a full and complete record on appeal, how much work and dedication goes into presenting these cases in a way that's going to make sense and gives your client the best possible avenue of success. And also some hope that the Court of Appeals is going to put aside any kind of partisan beliefs or anything that's a political non-issue for the courts. Because when you're appearing in these courtrooms, I know many of you have, as I have, you're pro-hawking in, you're going to a different state where you don't know everybody, where you're sitting there in front of a judge who's looking at you like, where the heck is Asheville, man? Like, I don't know where you came from. I don't want to think that my case is going to be decided on some political background. I don't want that bias or any kind of partisanship to dictate what happens to my client in that courtroom. And that really gave me a deep appreciation beyond just the criminal side, but in the civil side as well, how important it is to have judges who are going to serve neutrally, impartially, and fairly, because that last stop exists for the civil cases as well, and it has a tremendous impact on people's lives. And I want to know that when I step foot in that courtroom, I'm going to win on the merits, not based on whether or not I know that person or if there's some pre-existing relationship or extremist belief that's going to dictate that. I've now transitioned into a role. I have my own appellate practice and mediation practice here in Asheville, and I also serve as a Buncombe County Commissioner. So I've seen on the policy side, I've served on one too many quasi-judicial boards. I think I have the record for longest quasi-judicial hearing in Buncombe County history, up to about 10 hours, which is a blast, highly recommend it. And I think seeing the guidance or lack of guidance that we receive from our Court of Appeals and how critical it is that we have judges who have a diverse array of experience doing both civil and criminal work. Yes, a lot of the work is criminal, but a lot of this stuff requires you to get comfortable with areas that you aren't traditionally doing. And for me, having that diverse array of experience doing the civil practice at a high level, doing criminal practice at a high level, and now working in a policymaker role, I have a deep appreciation for what the role of the Court of Appeals truly is. So in those cases, whether it's in state court, federal court, or appellate courts, I know what it's like to sit in that chair as a defense attorney and pray and hope that your judges are going to be fair and impartial and are committed to just outcomes and applying the law. I look forward to serving with that same dignity and applying that same principle on the bench with a commitment to transparency and accountability.
Thank you, Mr. Moore. Our first question is going to be posed to Mr. Murray and Judge Thompson. So the same question for both of y'all who are running for seat 12. The number of civil jury trials in North Carolina continues to decline, making trial skills and experience harder to acquire and maintain. What challenges do you see to having civil jury trials that may be specific to our state? Are there initiatives that may make them more sufficient and less costly, therefore making them a more viable option for all parties to a suit? Which groups are taking the lead in North Carolina on these issues, and is there a way for the NCADA to collaborate with them? Understanding that's a multi-part question, you can answer any or all of it. We'll start with you. Okay, Mr. Murray, you want to go?
Thank you so much. I think trial skills are obviously a perishable skill. Without the reps, you don't get better at it, right? And so there's multifactorial why the number of trials in the state of North Carolina have gradually declined, whether it's mandatory mediation or maybe some policy changes at the legislative level. But at the end of the day, North Carolina is not unique. And so one of the organizations I think it would be beneficial for the North Carolina Association of Defense Attorneys to at least partner with is a data place, and it's the National Center for State Courts. You ought to look and see how jury trials nationally are trending. And you might be surprised that we're not an outlier. We're not an outlier. And so I think the bottom line from when I saw this question come through is, what's the goal here? Is the goal to get trial experience? And so one of the thoughts that I had on how can you get your young associates trial experience if they're not getting it on the civil side? And I can tell you as a criminal prosecutor, the indigent defense system in the state of North Carolina is on fire. And we need attorneys willing to take court-appointed cases. I'm not asking you to take 100 cases a year, but if you contacted your local indigent defense representative, they would gladly take an associate to take 10 cases and get some reps in superior court, trying cases, low-level felonies, assaults. It would be a tremendous benefit to the criminal justice system and get your young associates some reps on trial experience, picking a jury, advocating, opening statements, all the things that you might see as perishable skills that you're not getting on the civil side because of all the awesome pre-litigation work that you do that results in settlements. So that's a piece of advice that I would have based on my experience in the criminal justice system.
Thank you, Judge Thompson.
Having served as a district court judge and a superior court judge, I can tell you I advocated for the ADR because coming from a small county such as Granville County, we have two courtrooms, a district court room and a superior court room, and it's a constant fight to get to access to both of them. We're actually still dealing with the backlog from COVID and not being able to even do jury trials. And so any opportunity that we can have to offer mediation as an option to jury trial, it helps the clients get closure and get that answer that they've been waiting on. And it also speaks to our ability to move cases without continued delay. And so as a superior court judge, the first thing I looked at in the file was, have the parties participated in mediation yet or signed up for mediation? And then as a certified mediator, I would actually open and say, I commend the parties and their attorneys for participating in mediation today. You've probably saved yourself a lot of money and a lot of time where we're not going to be able to reach your case in a timely manner. And so with that, that whole experience of understanding that our court systems need help in resolving cases quickly for all of the clients out there waiting for an answer, ADR is there to help us. The Mediation Center still sends information to me on a regular basis about the trainings that are available for young and seasoned attorneys. But as a young attorney back in the 90s, I found it easy to find a mentor, a seasoned attorney or a seasoned law firm to volunteer my time to say, can I shadow you just to see how it works, how the ins and out of it all. And that's also a resource. I would just encourage the younger attorneys to find a seasoned attorney to go under their wings for as long as they will allow you to, and learn what the trial experience looks like with the jury. But certainly, ADR has had an impact on the jury trials.
Thank you both. Judge Zachary, we'll pose the same question to Mr. Eldred. But there's a Latin phrase that translates into judgments frequently become matured by deliberations, never hurried by process or precipitation. Other than the appellate record, briefs submitted by the parties, and our oral arguments, what sources do you rely on to help you reach a decision that's matured by deliberation?
That's a great question. You know, the Court of Appeals was designed to reach decisions through deliberation. And I think one often overlooked source that could help us reach a decision matured by deliberation is an amicus brief. In my opinion, there are three ways in which an amicus brief is useful to the court. First of all, it brings perspective to the court. It demonstrates the potential reach or practical ramifications of the court's decision. You know, and I always appreciate an alert to the perhaps unaddressed or unconsidered implications of a holding. You know, also, you know, the amicus is not restricted to the record on appeal. So an amicus brief can provide additional information or present facts in a different way than the parties' briefs. And so the amicus can discuss the holdings and experience of other states, present an alternative legal argument, place the case into the broader framework, or alert us to other pending cases. And then, of course, you know, the amicus brief, just by its very presence, signifies the significance of that case. Don't forget that we have a new appellate rule regarding amicus participation. New Rule 28.1 provides, among other things, that the amicus may participate in oral arguments for good cause. So I'm hoping to see more amicus briefs at the court.
Thank you.
Hello, NCADA. I am sorry I couldn't be there in person, but a judge unexpectedly required me to be in a hearing this morning. I've been asked what one aspect of the appellate process I would change if I could. Some or all of you may not like that there's no longer an appeal of right based on a dissent. Most of my clients don't like that either because they would take a second bite of the apple if they could. I'm not particularly concerned about the Supreme Court's caseload. Sorry, Justice Riggs. It doesn't bother me that they have to review a Court of Appeals opinion just to issue a per curiam opinion of their own. So I would reinstate the notice of appeal, the appeal of right based on a dissent. To answer the question, though, I would change and clarify the rules about the notice of appeal. That document has an oversized importance in every appeal. To get it right, you have to monitor case law, which may or may not be consistent across panels. You have to cross-reference statutes, because if you mess up the document, you'll have torpedoed the appeal before it even starts. And you may not find out that you torpedoed the appeal until the opinion comes out. It is similar to the times when the Court of Appeals would dismiss appeals based on technical rules violations or wouldn't address an argument because an assignment of error wasn't included in the record that you wrote months before you filed the brief. We shouldn't have to file a cert petition just to protect an appeal. We shouldn't have to file a cert petition out of an abundance of caution. I would change the rules so that we don't have to. Thanks for listening. Have a good time.
That leads into our next questions on a similar theme there. I think amicus is something that we've talked about as an organization as far as the recent rule change and its role going forward. The candidates for seat 15, somewhat related question. If there was one aspect of the appellate process in North Carolina that you could change, whether it's court procedure, an appellate rule, some aspect of the practice of appellate lawyers, or something else, what would that be? And this is for Judge Freeman and Mr. Moore. Go ahead.
Okay, so on this, I gave this a lot of thought for this question, and there's one thing I wanted to point out to you all, that experience matters. And you know, when I was telling you about myself, I left out one thing. I've served in the United States Air Force since 2013. In October, I'll promote to major as a JAG officer. So when we're talking about this question, the one thing I thought about, obviously I'm running for the Court of Appeals, so I think it's pretty good. I respect all the justices and judges that came before me, but as a judge and as a former prosecutor, as an officer in the military, there's always improvement for communication. Many things go on in a courtroom, but there's a lot of work that happens beforehand. Communication can always be improved through counsel, opposing counsel, attorneys with their clients, clients with their attorneys, the court giving clear, concise rulings, the expectations to be held in their courtroom. And I welcome you to come to Rockingham County anytime, or Caswell County when I'm serving, see how I run that courtroom, see how I communicate with counsel, clerks, bailiffs. I think that is something that is vital to this. And that's the one thing I could see that we always have room for improvement. That's my answer. Thank you.
Sure, thank you. Mr. Moore.
Thank you. Not a particularly long one, but one that resonates with me very, very much so right now. I had a recent case before the Court of Appeals where trial counsel had neglected to properly file a notice of appeal. There was a defect in the document they submitted, and it was frustrating because I had to explain to that client that this person who they had sat through a trial with and put a lot of faith in, it was a criminal case, so their liberty was at stake, had made an error that might cost them an opportunity to have their case reviewed. And I go back to thinking about what the purpose of our courts truly is, which is just outcomes. And if you're looking at just outcomes, an extremely technical error that was not made by the client, but a mistake of counsel at the trial level, was going to have a disastrous impact on this person's life. And I'd submit a petition simply to have the court review it and hope that they'll allow his appeal to proceed and us to address some substantive issues in his case that I think he deserves to have heard. And I guess if I had my wish list of what I wish I could change, is not allowing someone's due process rights to be so permanently prejudiced in a way that they lose viable legal arguments over a mistake that's beyond their control. This person would have no way of knowing whether or not their counsel did that correctly. And I think if we're going to talk about just outcomes, we have to at least consider and look into, are we actually hitting the mark in terms of what justice looks like if folks are paying that kind of penalty for trial counsel mistakes.
Thank you. I want to thank the members of the judiciary who are out in the audience. I want to thank the candidates for traveling from all over the state to be with us today. This has been recorded. It will be on the NCADA website. We will also post Mr. Eldred's video submission as an additional feature. Thank you again. We appreciate your time and attention.